The decision regarding Microsoft and Activision Blizzard's merger has been reached regarding the application for a preliminary injunction by the FTC. The judge has come to a decision. We are going to read a decision here. United States District Court, Northern District of California. Preliminary injunction opinion. In December 2022, the FTC initiated an administrative action to block Microsoft's acquisition. The gist of FTC's complaint is Call of Duty is so popular and such an important supply for any video game platform that the combined firm is probably going to foreclose it from its rivals for its own economic benefit, consumers' detriment. Discovery in the administrative action has closed, and trial before an FTC judge is scheduled to commence on August 2nd, 2023. Now, let's assess this claim. The gist of the FTC's complaint is Call of Duty is so popular. This is not the gist of their claim. This is a straw man. This is not what the FTC was arguing in their application, in their complaint. And we can actually see this. If we go to the document, let's see what the FTC actually said, right? Defendants' arguments might be persuasive if they were aimed at the applicable law, the FTC's actual claims, and the record evidence. They are not. Defendants assert that the upcoming hearing must decide the merits of their deal, lest they be forced to renegotiate their self-imposed July 18 deadline for completing their transaction. But the law, as this court has already ruled, is that the FTC need only present evidence sufficient to raise serious, substantial, difficult questions regarding the anti-competitive effects of Microsoft's acquisition of Activision. Order at defendants assert that the FTC's central claim is that the combined firm would withhold certain Activision content, in particular Call of Duty, from Sony. But that is a straw man. That is a straw man. The FTC's actual claim is that it is reasonably probable that the combined firm will have the ability and incentive to harm competition, including from future competitors, in several ways in multiple markets where the competitive effects of this transaction will be felt, including consoles, content subscription, and cloud gaming services. So that is what the FTC actually said. It's not just about Call of Duty, it's about the entire library of Activision games, which includes Overwatch, a very popular game, Diablo 4, one of the most popular games on console right now, World of Warcraft, one of the most successful MMOs of all time, probably the most successful MMO of all time. And so the concern is that this content will be withheld. It includes Call of Duty, but Call of Duty is not the only item. So I don't know why the judge is focusing so much on Call of Duty when entire days of the trial were also about the cloud gaming space. Not just Call of Duty, but the entire library of Activision. We don't know how this will affect. Will it mean Overwatch is foreclosed from being on PlayStation 5? Or do PlayStation 5 owners get an inferior version? Let's continue reading. 4 weeks ago, the FTC filed this action to preliminarily enjoin the merger pending completion of the FTC administrative action. Because the merger has a July 18 termination date, expedited proceedings were commenced. After considering the parties' voluminous pre- and post-hearing writing submissions, and having held a 5-day evidentiary hearing, the court denies the motion for preliminary injunction. The court denies the motion for preliminary injunction. So the FTC has lost. The FTC did not manage to get the preliminary injunction to delay the merger until a proper investigation, which is bad for gamers, it's bad for consumers, because they should allow a proper investigation. There's no rush for for this merger? Why is there such a rush to get it through? I'll tell you why. It's because Microsoft knows that the evidence is against them, and proper investigation would show this. Proper argumentation and proper representation of all of the facts laid out in a court would show that the evidence is against them, that they have a history of anti-competitive behavior, and that this is a bad deal for the future. Now, Judge Scott Corley did not consider the voluminous pre- and post-hearing writing submissions. If she had, she would know that it wasn't just about Call of Duty. It's not the gist. This is not the gist of the FTC's complaint at all. This is a straw man. It's a complete straw man. And the FTC, I feel bad for the lawyer, the FTC lawyer. He did an amazing job. But ultimately, the judge was biased. Why was the judge biased? Probably because she has a clear conflict of interest in the case. Her son works for Microsoft. I'm baffled as to how the case was even allowed to be taken up by the judge. So we hope now the FTC will issue an appeal and will point out that the judge was biased, had a clear conflict of interest, and must be denied. The motion must not be accepted by the judge because it was done on false grounds, conflict of interest grounds, which I have no idea how she was allowed to take the case. This would not be allowed to be taken in any other country. It's clear corruption. It undermines the confidence, the public confidence in the courts, the fairness of the courts in America. Speaking as a British person, it undermines my confidence and faith in the American justice system, and it makes me feel like the justice system is corrupt and allowed clear conflict of interests. Anyway, continuing on, the FTC has not shown it is likely to succeed on its assertion the combined firm will probably pull Call of Duty from Sony PlayStation. Now, this is again not the only assertion. It's not just Call of Duty, it's Diablo, it's Overwatch, it's World of Warcraft. It's all of these other games. It's the entire Activision Blizzard library, right? It's the entire library. So what games does Activision Blizzard actually make? So what do I mean by the entire library? Let's have a look. Okay, so it's loading. Okay, so let's have a look at what games they actually make, right? All games. How do I? Diablo, World of Warcraft, Call of Duty Modern Warfare 2, Warzone, Overwatch 2, World of Warcraft Classic, Hearthstone. This is a huge card game, strategy card game. Hearthstone is on mobile as well. Diablo Immortal, Call of Duty Black Ops Cold War, Call of Duty Modern Warfare, Call of Duty Vanguard, Diablo 2 Resurrected, Diablo 3, StarCraft 2, Warcraft 3, Warcraft Arclight Rumble, StarCraft, Call of Duty Modern Warfare 2 Campaign Remastered, Heroes of the Storm, Call of Duty Black Ops 4, Crash Bandicoot 4, Blizzard Arcade Collection, and this is Warcraft 3 Reforged, the remastered version. And so you see how many games they actually make here, right? And the judge somehow has only focused on Call of Duty. She has completely ignored the fact that all of these other games have the potential for foreclosure, as the FTC has put forward, as the CMA has also put forward, and as New Zealand and Canada have also become aware of these facts and highlighted their importance. But somehow, despite Canada, New Zealand, UK, America, all of the major English-speaking nations, the nations that actually have any idea about this stuff, rather than foreign nations that probably don't understand the nature of the contracts and stuff, because you want people who have English as their first language. You don't want any kind of English barrier of language, which could happen with the foreign regulators, right? But English is the primary language of Canada, UK, America, New Zealand. So this is why their judgment, I feel, is more important here, because they can assess the claims of Microsoft, whether the deals they've struck with the various companies actually hold weight. The FTC has not shown it's likely to succeed in its assertion, or that its ownership of Activision content will substantially lessen competition in the video game library, subscription, and cloud gaming markets. Now, they don't need to show this. We've seen the intention from the emails. We know Microsoft's intent from the emails we've seen. So let's see what the judge has to say about the cloud gaming industry, which she doesn't understand at all. Video game consoles are consumer devices designed for and whose primary use is to play video games. Okay, that's convenient. All of this is redacted because she doesn't want to show that she's wrong, right? While the consoles were once the predominant form of home gaming, they now represent a smaller share of the video game revenue than either mobile or PC. Mobile gaming, most gamers today play on mobile devices. So that's the entirety of her cloud gaming section, and we don't even know what it says, which is really, really strange, right? We don't even know what it says, the most important part of all of this. Okay, let's just skip to the conclusion. Pretty annoying that it's all redacted. I don't know how we can see the unredacted version, but you see her signature, Jacqueline Scott Corley. I've raised concerns about her impartiality in this case, and I stand by that. Her conclusion is Microsoft's acquisition of Activision has been described as the largest in tech history. It deserves scrutiny. That scrutiny has paid off. Except you haven't given it proper scrutiny. You are clearly biased. There was no proper scrutiny by you. You misrepresented the FTC's arguments and you strawmanned the arguments, making it about Call of Duty when it was about more than that. That scrutiny has paid off. Microsoft has committed in writing and public and in court to keep Call of Duty on PlayStation for 10 years in parity with Xbox. It made an agreement with Nintendo to bring Call of Duty to Switch. And it entered several agreements for the first time to bring Activision's content to several cloud gaming services. This court's responsibility in this case is narrow. It is to decide if, notwithstanding these current circumstances, the merger should be halted, perhaps even terminated, pending resolution of the FTC administrative action. For the reasons explained, the court finds the FTC has not shown a likelihood it will prevail on its claim that this particular merger in this specific industry may substantially lessen competition. To the contrary, the record evidence points to more consumer access to Call of Duty and other Activision content. The motion for a preliminary injunction is therefore denied. This is in capitals. You know, she really wants to emphasize that it's denied. Have it in capitals. Denied. You can imagine there's a stamp thing she's smacking down. This opinion constitutes the findings of fact and conclusions of law required by Federal Rule of Civil Procedure 52. Given the compressed time the court had to issue a written opinion in light of the impending termination date, there will likely be errors in the citations. So she's basically trying to make excuses why she made errors. There was no compressed time because she didn't have to honor the impending termination date. This was Microsoft's self-imposed. Microsoft and Activision's self-imposed termination date. There was no legal basis to have a compressed time that the court has to issue an opinion. The deadline was 17th actually, so she had more time. She could have used more time to, I think the deadline was 18th or 17th, right? So she would have had more time. And for the same reason, the opinion does not address every argument the FTC makes, because you can't address it, because you know you're wrong. And it's 196-page post-trial submission. Okay, we're gonna have to have a read of that. I need to have a read of this. I have no idea where I can find this. It's quite annoying when you're trying to investigate the claims and discoveries, and you want to understand things, right? But it's so hard to find these documents. Where even are they? The opinion does not address every argument they make, nor cite every piece of evidence supporting the court's findings. Because the decision on the FTC's request for a preliminary injunction effectively terminates the litigation and constitutes a final order, this case is dismissed. See FTC versus Hackensack Meridian Health Incorporated. The court modifies its temporary restraining order such that the temporary restraining order will dissolve at 11:49 p.m. on July 14th, 2023 unless the FTC obtains a stay pending appeal from the Ninth Circuit Court of Appeals. Of course, the FTC is probably going to appeal. They're going to say that Judge Scott Corley had a conflict of interest. Her son works at Microsoft, and that highlights a clear conflict of interest. This opinion is filed under seal. At the same time it is filed, the court will file a redacted version under seal. In an abundance of caution, it is overly redacted. You mean you don't want the public to know that your decisions were wrong? You don't want them to see why you don't understand cloud gaming. You do not have technical competence. You were clearly out of your depth. You don't understand how latency works. You don't understand even the basic names of the services. You don't understand Xbox Game Pass is the name of the content library subscription. xCloud is the name of the cloud gaming service. You don't know the basic terms. It just shows you have not even bothered to investigate properly. The parties shall meet and confer with the non-parties, and on or before July 18, 2023 submit a new proposed redacted version of this opinion. It is so ordered. Dated July 10, 2023. Jacqueline Scott Corley.